is present via Zoom as well.
Morning, Judge.
All right, what is this on for? It says motion to increase bond.
Yes, Judge, I did not file a motion. So what happened in this case, Your Honor, is that this is a media case. He was arrested for punishable by life crimes. He should have been held no bond. However, this is one of those charges where the PBL comes in at the very end of the charge, and I think the clerk's office made an error, allowed him to bond out prior to seeing a bond appearance, or prior to going to bond hearing. Somehow I think he was given standard bond of $21,000, $10,000 on count 1 and count 2, and then $1,000 on count 3, Judge. My issue, Judge, is that there's no stay-away order on the case yet. That's why, Your Honor, asked the defendant to be present. I also am very concerned that the defendant has been essentially terrorizing the victim. I mean, the victim's 14 years old, and there's been a lot of...
Since the arrest?
Since the arrest, Judge, he's been very communicative on, he's been very vocal on social media, on, there's been videos of the victim drugged by this defendant leaked online. Your Honor, on this case, we do have DNA showing that the defendant's sperm was on the victim's clothing.
Your Honor, may I ask why any of this is appropriate considering no motion has been filed?
Yeah, that's the thing. I don't like being ambushed with all of this. This is...
Nor do I, Your Honor. This is entirely inappropriate.
If in fact the state was seeking a motion for pretrial detention, they should have done it. I mean,
well, Judge,
now as far as the stay-away order is concerned, I can certainly do that, but I just can't go ahead with allegations from the state without giving notice to the defense. I mean, certainly I would hear it, but I can't do this in a vacuum like this. So the only thing that I know that this was reset for, which was advised to me the last time, is that the stay-away order was not properly presented, and I'm ready and able to do that at this time.
Judge, you are the first appearance, Judge, regarding the information that was filed, Judge. He was charged with a total of 6 counts, Judge. And they're different. They're all different from the charges, except for
Again,
one.
Your Honor, excuse me, I have to interrupt. This is entirely...
Hold on. Mr. Terrace, hold on. Let her finish. Just let her finish. I'll allow you to make your argument. Go ahead.
Thank you, Your Honor. He has been charged with 6 counts. One of them is the same, but there's 5 additional counts, Your Honor. So Your Honor does have to set bond on those counts. And then the stay-away order has to be set. I will be filing a motion to increase bond. And I understand that Your Honor does not want to be ambushed. I will file that at a later time, but I did want to put the court on notice that with regards to the other bond amounts that need to be set, Judge.
All right.
So we definitely have to address bond.
Okay, now, did you have a response, Mr. Terrace, and then I will deal with the information.
Yes, Your Honor. We don't, there is no motion pending before the court. The state, no one, our side certainly did not ask for a schedule bond. That was something that the state of Florida decided to place on this case. Those charges were higher charges, and they were downfiled. Doesn't matter that there was more charges that were listed on the information. These are downfiled charges. Mr. Noak is out on constitutional bond. There's no motion pending before this court, and there's no need for Ms. Garcia to just ambush us with additional information that she feels the court and the media in her speak should hear. So we are entirely prepared to address a motion that's before us. Not another word needs to be said regarding a motion that's not pending before this court. We do and are prepared to address the no contact situation today.
Okay. Now, first things first. First thing I have is I have an information that's been given to me by the clerk that was filed on September 14th, which was 3 days ago. And again, I have many cases on my calendar. Has this defendant been arraigned on this information?
He has, Your Honor.
He has, Judge.
He has. Okay, so he has been arraigned, and I am looking at, there are a total of 6 counts. I, at this point, do not see that there are any non-bondable offenses, and there appears to be a second-degree felony for count 1, second-degree felony count 2, 3 is also second-degree, 4 second-degree, 5 is a first-degree misdemeanor, and 6 is a third-degree felony. So, have all of the bonds been addressed at the time of the arraignment?
No, Judge.
No, Your Honor.
Okay, well, that's what we need to do as far as that is concerned. And I will, what was he out on previously? Let's just start with that.
He was out on count 1 and count 2 for $10,000 each, and then count 3 on the information was a misdemeanor, so that was $1,000. So right now he has a total of $21,000 bond.
Okay, so 1 and 2. So what was added in the information?
So the counts 1 through 4 are all second-degree felonies. Those were not on the information on the
Were not
arrest.
originally charged?
Correct. Also, Judge, count 6 is interference of custody. That one also was not charged. Count 5 was charged as count number 3 on the arrest form. So that one should say $1,000.
So then what was the original 10,000? If you're saying that 1 through 4 was not charged and then 6 was not charged, then what was the original charges where he got the two $10,000 and then $1,000?
So the original charges was count 1 was engaging in sexual activity with a child in familiar custodial authority. That was actually a PBL, but that charge, when it's input into the arrest form, it looks like an F1. So on that count, he was given $10,000. Then on count 2, it's sexual battery of a victim 12 to 17 years of age. That's an F1. That was another $10,000 bond. And then count 3 is count 5 on the information.
Okay. All right. So as it relates to the new information, the court is going to, on count 1, the defendant will be given a bond of $10,000. On count 2, defendant will be given a bond of $10,000. On count 3, defendant will be given a bond of $10,000. On count 4, defendant will be given a bond of $10,000. On count 5, that will be a $1,000. And count 6 will be $5,000 bond. All right, does corrections have that? Well, all right, clerks have that as well?
Yeah, I have it, Judge.
Okay. So he is going to need to post those additional amounts. If it was $21,000 originally, it's now going to be
46.
$46,000 additional bond. That's as to that issue. Anything further on that issue? And then we're going to get to the stay away order.
So, Judge, I do think it's important to note that he is a California resident. So I would ask that Your Honor consider that when setting the bonds. Are these standard bonds, Judge?
I do not know what is considered a standard bond on these, but these are the bonds that the court's going to be giving.
Okay. So, no, Judge, I'll be filing a motion to increase bond due to the facts of the case. The other, in addition to the bond, Judge, it's just a stay away order I think that we need to address today.
Understood. All right, anything further from the defense as to the bonds for right now?
Your Honor, I don't see that the state has laid any grounds for why the bond amount should be increased. We
Well,
believe
we're not
that
there yet. We're not there yet. There's no discussion right now. That's not what's before the court. The court just is setting bonds on the new counts.
these counts are downfiled. I just want to make that clear from the record, even though there's more of them.
Understood.
So but we would object to the entire bond amount increasing, considering these are downfiled charges.
Okay. Your objection is noted.
Other
Now-
than that, no, Your Honor.
All right, as it relates to the stay away order, okay, so apparently these are minors. If I can have the defendant sworn.
Mr. Noak, can you unmute yourself?
Raise your right hand. Do you swear affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Okay, so you can put your arm down. Can you tell me your full name and your date of birth?
Michael Eugene Noak Jr., born August 10th, 1983.
All right, thank you, sir. All right, so you are currently charged under case F21 14438 with several counts involving a minor victim. And the minor victim is identified as T like Thomas, S like Sam. Do you know who that is?
Yes.
All right. Sir, you are ordered that you can have no contact with TS. And when I say no contact, that means no direct contact or indirect contact. Indirect contact includes you cannot communicate with this individual via social media, you cannot call, you cannot text, you cannot reach out to this individual or in some way attempt to communicate through a third person. Do you understand that, sir?
Yes, I do.
All right. Now, I will just advise you and admonish you. This means what it says. I do not know whether or not you were given any type of a stay-away order, but as of right now, this stay-away order is in effect in that if you violate any terms of this stay-away order, that may be grounds for your bond status, your pretrial release status to be revoked, and you will be immediately taken into custody. Do you understand that, sir?
Yes, I do.
Okay. Anything further on that issue from the state?
No, Your Honor.
Anything further from that issue from the defense?
No, Your Honor.
All right. That is all that the court has before me. Are we done? Ms. Garcia?
I believe so, Judge. I just want the defendant to be aware that he should not be posting any social media posts or anything about this case, about the victim in this case. I know that there was a video of the victim leaked on social media. I'm concerned about the victim's, well-being regarding this case. So I just want to make sure the defendant's well aware that if that happens, we will be filing the appropriate motions to avoid that from happening.
All right. Well, just
May I
so
respond,
it's
Judge?
clear. Yeah, just so it's clear. I just want both sides to know allegations are allegations. I certainly will respond to some type of evidence shown to the court that the defendant has somehow violated the court's order. Now, let me hear from the defense.
Judge, I just want to make clear for the record as well that this arrest, Mr. Noak has been compliant and has known about this investigation for far before his arrest. Has come down and voluntarily submitted 2 warrants along the way because he has nothing to hide. Any allegations that the state is making about their fear that he might have been tampering or attempting to scare the alleged victim via social media, there's no order saying that he is not allowed to use social media. And I also would like to make clear that it took the state till 4:56 p.m. on the night before the arraignment to file an information here, and a reduced one. If they were so scared, they had ample opportunity to file a motion in the meanwhile, and they failed to do so. So I don't believe that Your Honor has taken into consideration any of the arguments that they've put forth regarding why they believe bonds should be increased, because that's inappropriate.
We're not there. I'm not even entertaining it. So let's not even. I don't even want to hear anything about it because nothing's before me as to an increase.
Well, Your Honor has the ability to set the additional counts at ROR.
Well, I'm not. I can tell you I'm not. Based upon the only thing I have in front of me is an information. That's what I've decided as far as the bond is concerned. That's it. Nothing more, nothing less.
Well, we would object to Your Honor taking into consideration any of the statements made by Ms. Garcia in reaching that determination.
Okay. Now, however, I do need to just advise Mr. Noak, based upon some of the arguments. I don't know what is out there that has been posted, but I will advise Mr. Noak that if in fact there is evidence shown to the court that you have somehow been responsible for submitting some type of social media involving this victim, you may have a First Amendment right, but it is limited. And if the state can show that this was done with some type of intent to either harass or intimidate a witness, that's serious. So just keep that in mind. You certainly have a First Amendment right, but if you do something that in somehow is intended to intimidate this witness, then the court will listen to what the allegations are and what evidence the state has presented. I think that can be the last word on this matter. I have a December 3rd report date. What is that on for?
I believe that was just for the status, Your Honor, case disposition, regular
Okay,
course.
perfect. All right, as of right now, that's the next date that we have on this case. Okay, thank you, everyone.
Thank you so much, Judge.
Okay,
Thank you, Your
take
Honor.
care. All right, bye-bye.
Judge, any word from TGK?
That's it. All right, listen, I came out impromptu. I wasn't planning on on going live, but then I saw that this was being broadcast live, and I thought that you all would want to see and know what was going on. So I'm just going to give you an update on what it is that I know so far. You know what? I wasn't really prepared to do a video. For those of you who got in late, just scroll the video back to the front. We spent the first 14 minutes going over what happened live in court today. I want to show you two different things, okay? All right, you know what? Let me calm myself real quick. Hello, Knockouts. Tanya TKO here. And as you know, I am a self-love specialist from TanyaTKO.com. I hope you learn how to love yourselves and one another. On this channel, we use viral video topics as teachable moments for what self-love or self-abuse looks like in your own life. And today we're talking about Brother Polight, Michael Noak, aka Brother Polight, who was arrested about a month ago. Tasha K broke the story with the police report and everything. There were questions as to whether or not this was real and this, that, and the other. Let me just state this right now. His DNA was found on the child. His DNA, his sperm. They did, oh my gosh, this is just so much. I'll play back the beginning of, for those of you who are confused.
Mr. Noak is present via Zoom as well.
Morning, Judge.
All right, what is this
Listen.
on for? It says motion to increase bond.
Hold on.
Yes, Judge, I did not file a motion. So what happened in this case, Your Honor, is that this is a media case. He was arrested for punishable by life crimes. He should have been held no bond. However, this is one of those charges where the PBL comes in at the very end of the charge, and I think the clerk's office made an error, allowed him to bond out prior to seeing a bond appearance, or prior to going to bond hearing. Somehow I think he was given standard bond of $21,000, $10,000 on count 1 and count 2, and then
I just want you all to hear where she talks about the semen of his semen on a child.
My issue, Judge, is that there's no stay away order on the case yet. That's why, Your Honor,
Okay, right.
asked the defendant to be present. I also am very concerned that the defendant has been essentially terrorizing the victim. I mean, the victim's 14 years old, and there's been a lot of...
Since the arrest?
Since the arrest, Judge, he's been very communicative on, he's been very vocal on social media, on, there's been videos of the victim drugged by this defendant leaked online. Your Honor, on this case, we do have DNA showing that the defendant's sperm was on the victim's clothing.
Your Honor, may I ask why any...
All right. You heard that. I'm telling you, it breaks my heart that there are people that will hear that his sperm was found on the child. I want you to take that part and rewind it and play it back for anybody who comes onto social media confused about what is going on here. His DNA was found on the child. That's it. The child had a swollen, bust up mouth. She had been plied with substances, alcohol or some narcotics even, this being alleged. So I want to know, how can anybody come to social media and defend this? I want to show you two different things, right? The two things that I want to show you are, I want to show you his social media page. Actually, I was being harassed earlier today, right? I'm going to show you something real quick. And I want to thank this person for harassing me, right? I want to thank this person for harassing me because I didn't even know that Noak had made a video. I'm going to show you a video from Noak, and I'm going to show you the charges, right? Because Noak is going around saying that both felony charges have been dropped. Let me show this to you, right? Let me show this to you real quick. All right, give me 1 second. Let me open this up. Let me just download this real quick, pull it up on my computer, and then open this up for you all. I just want you all to read this real quick because Okay. All right. Here we go. Here we go. I just want to show this to you. All right. So somebody wrote this to me today, right? Let's see if I could get this here. Where's my, give me 1 second. I just want to get my things back together. Okay, I'm going to read this for you. Okay, so here we go. Let me read this to you right here, right? So there's a person by the name of Majid STR on Instagram who wrote to me, and he wrote to me saying, Tanya TKO TV, you clearly haven't traveled enough to generalize. He was remarking on the video that I did where I said that black men covet what comes out white men's penises, right? I did that video. It's on Instagram. He says, you clearly haven't traveled enough to generalize. Come to Africa and see how their wealthy, influential, and power African men and women coexisting with mutual respect with no malice. I think you have some trauma from past relationships that make you hate black men. Sad truth. Let me tell you this, right? Let me just say this. If you are a black man from Africa, right, and I am not addressing you specifically, shut your fucking mouth, okay? Shut your fucking mouth. There's a woman saying this to you. Shut your fucking mouth, because you don't want me to speak on what's going on in your respective countries. If there's anybody here who knows me, who knows whether or not Tanya has traveled or whether Tanya has not traveled? Let me fix my camera for you all. Right? Who knows whether or not Tanya has traveled or haven't traveled? I wrote back to this guy. The comment is on Instagram. I told him to put his travel resume next to mine. I told him the time, length, whatever, number of countries visited, and the amount of time visited in those countries, right? I out-traveled them. I can guarantee I've out-traveled him. He can put his, and sir, you can write to me. Come, bring it. Put your travel resume next to mine. Pound for pound, I outweigh you. In real life and on paper, son. Sit down. Sit down, a woman is speaking. But then I saw another comment. This is how I was made aware of this, right? This is how I was made aware. He tagged me on Noak's page. This is how we got here today. He tagged me. And he says, Brother Polight, you got to check this Tanya TKO TV woman who has been gunning for your downfall. Honestly, I believe this woman hates black men, accusing you of the things without facts. Very sad human being. Let me stand up and say this to you. Yes, Noak, come. Come, son. You wanted to come. Because listen, you got enough on your hands. You don't want none of this over here, son. Sit down in your courtroom in your baggy ass suit, your oily ass face, and sit there and get your charges, boy. Because the white man in this country got something for you. Listen, if you didn't know, now you know, mother effers. You sit there in your baggy polyester suit, stepping out of somebody else's rented vehicle, your rented Rolls. Listen, you, boy, if I'm not talking to you, shut your damn mouth. Shut it. Shut it. Because you don't know what you're talking about. Listen, I don't know what the court system is like over there in your country, son, but let me tell you something. Here in this country, his DNA was found on a child, and you have the nerve to open up your goddamn mouth to defend this man. Is you crazy? I don't believe it. I don't believe it. So nonetheless, I said, well, what is this video that he's tagging me on? This is how we got to where it is that we are today. Let me show you how we got to where it is that we are. I'm going to pull up the video, right? Here we go. Let's take a look. Listen, if there's anybody who knows me, I don't give my love, my hate, my disdain, my allegiance based on people's genitals based on the amount of melanin they have or don't have. If you're an effed up individual, you need to be taken down. Listen, if you hurt children, there is no place for you in civilized society. I have no allegiance to people who hurt children, none whatsoever. I will call you out each and every time, especially if just desserts has not come to you yet. Listen, no, it looks like I have to log in. Give me 1 second. Give me 1 second. I have to log in because I need to get into Instagram so that we can play this video for you so that you can see what it is that I'm talking about. Listen, I don't know where it is that you come from, boy, but let me tell you something. The rules are different here. I don't jump in a line because some person with a penis tells me to. You got no governance over here, mother effer. As a matter of fact, you got no governance across the world, son. As you sitting there in countries where men of other races and nationalities are coming, buying up your land, running your businesses, and taking the wealth out of your country. Don't sit there as there's the ground that you sit on is pilfered from beneath your feet and talk to me yet, son. No, sit down and take care of your own front yard. No coming on mine. All right, I'm just logging into Instagram right now, just minding my own business on the internet. Did you see I didn't even get a chance to put on an eyebrow today? And that's all right. That's all right, because the message that I have transcends eyebrows. And there will be some effeminate males who want to be fashion designers who are like, oh, you don't have an eyebrow. Yeah, build something, bum. Build something. All right. Let me go to the tags. I'm going to show you. Because it's still there. Because I wrote back to him about putting his resume up against mine pound for pound. The comment is there. Let's see. So let me find this. You know what? Rather than me looking for the comment, let me just go to Polight's page. Simple as that. P-O-L. Let me see. Oh, here it is. P-O-L-I. Here it is. Perfect. All right. This is the video he tagged me in. Let's pull this up right here. Hold on. Let's get this. Click. Go to post. Let me get my screen up. Give me 1 second. For those of you who have an issue with me navigating through, you're not knockout made. Go to some other platform where they deliver crafted videos for you. We create content on the spot here. This video is live. As you see the comments scrolling across the screen, the video is live. You are a part of the show. So come with it, no? Here we go. Look upon this, yeah, we have it. Let's play this. I heard the first 2 sentences that he said, and then I contemplated, do I go live on this or do I not? And then I happened to come to YouTube and saw the live footage. So then I was like, let me just go live real quick. Let's play.
Both first-degree felony sexual assault charges have been dropped. Let's start it off with this conversation right here. Again, I won't be talking about the case specifically for all the right reasons. I have legal counsel. They're going to do what they got to do.
So this was posted 1 day ago. It's on his page. I didn't even know. But thank you to the buster who tagged me in it. You know what? I'm telling you, there's something seriously the matter with a man who would defend a man who has been subpoenaed. They are stating in court. This is not a rumor. This is not, do you think his DNA, his bodily fluids were subpoenaed. He submitted his bodily fluids and they matched it with the fluids that were found on a 14-year-old child, and they're his fluids. This is not some, I heard on the internet. No, you saw it for yourself, right? So there's a special place in hell for people who hurt children. Think about the innocence of a child, that you can't give a child a chance to live a life, live a full life that you want, that you so hate this world, that you would squelch off the chance of a child having a full future. That now their introduction into sex and sexuality comes from you battering them. Come on. How much must you hate children? How much must you hate this world to be that type of person in this world to hurt a child? The innocent, the ones who have done nothing to anybody, who didn't even ask to be here, that you would hurt a child. And to the people who defend the abusers of children, I got no love for you either. And let me tell you something. It angers me. Let me tell you how it angers me in my soul. It angers me in my soul. And you know what? Good men out there, instead of coming to me and telling me that there's some good men out there, it angers me in my soul that these bums, that these derelicts, that these reprobates, that these heathens, that they would confuse my condemnation of their actions and align themselves in the pot full of men. No, I don't hate men. I don't. And because I know good men, because I know what real men, what true men, what upstanding men are like, I condemn your behavior because I know that your dysfunction is not normal. I condemn you because I know what exists out there and I know how good men can be. So I condemn you. Don't align yourself with regular men. You are an effing bum, a heathen, a derelict, a reprobate. You're disgusting. The abusers of children, there is no place for you in civilized society. I can't speak forthrightly about where I feel the place for you is, but you can imagine there's no place here for you among us at all. I'm going to go back to this video. We're going to jump around. His video was 45 minutes as he sits there going off, pontificating and just spewing his madness. It's unbelievable.
What we all going to talk about?
Oh, you know what? As a matter of fact, let's go back to the very first sentence. Let's go back to the first sentence. Let's go back.
Both first-degree felony sexual assault charges have been dropped.
All right. That is his assertion. Let me tell you what the truth is. Because you know what? The thing about it is that we act like there aren't liars among us. We act like there aren't people who just tell falsehoods right out there with a straight face. We act like there aren't people who twist the truth and say their own version of the truth and come up with all different types of, let me tell you what the truth is, because I looked it up. This is public record. See, I don't know what it's like in other countries rife with corruption. But here, charges are public record. You can look it up. You too, from whatever respective country, maybe you might have, if you can get an IP address, maybe you might have access to the public record. I don't know. I don't know. But let me pull this up for you so that I can show you, what happened. And I spoke to a lawyer earlier today. Let me show this to you. All right. It's a little small, so let me take my camera off and just show the whole screen so that I can show you what we're looking at, right? All right. So these are the charges for, let me scroll down so that you can see who we're looking at right here, right? So that I can show you. Michael Noak. You see that name right there? Date of birth, 8/10/1983. All right. It shows the judge's name and it shows the information about his arrest. I'm going to show you. We're going to scroll down here, right? These were his original 2 charges. They were both felonies. I want you to look down at the bottom here, okay? You see where the mouse is, 1 and 2? Okay. So his original charges were engaging in child, FASEX 4/14, felony, right? When they went to court, this was in August that this happened. I'm going to show you further down. When they went to court, they did no action on that. Sexual battery of it says V12 through 17. Okay, victim 12 to 17 with the defendant 18 or plus, which is a felony. When he went to court, it says no action. So they didn't proceed on that, right? They didn't proceed on that. So let me go forward. Let's scroll down a little bit so that you can see what the truth is, right? So that you can see, right? All right. So he went to court. Remember when they got his DNA and then and then you can look this all up yourself. So all of this is August. And then here comes September, which is where it is that we are right now, right? So what happened is when he was arrested originally, they had arrested him for these 2 felonies right here, right? They arrested him for the 2 felonies. But what ended up happening is when he went to court, they decided not to move on those 2 felonies. And they added 1, 2, 3, 4 felonies and a misdemeanor. Now there are 5 charges against him. So when he comes forward and he's like, both felony charges have been dismissed. You heard his statement. We'll pull his statement for you so that you can hear that again. So that you can hear his statement again, right? Listen.
Both first-degree felony sexual assault charges have been dropped.
All right. They decided not to move on those, but he doesn't say anything about them adding 4 more plus a misdemeanor. Now let's take a look, and you can Google these if you'd like, right? I'll Google 2 of them for you just so that we can be on the same page, right? So the new felony that was added is L&L MOL child 12 through 16, which is lewd and lascivious. I Googled it. I did a copy and I pasted this into Google, right? And what came up with was lewd or lascivious molestation in Florida. Can you see this? Let me move this over so you can see. Do you see that? Lewd and lascivious molestation, right? And who was the lewd and lascivious molestation on? It was on a child between the ages of 12 and 16. This is not a joke. This is not fantasy. This is not, no, this is for real. Charge number 2, he has 2 counts of lewd and lascivious molestation of a child between the ages of 12 and 16, because the child is 14, right? Then we have L&L conduct with the child under the age of 16. Lewd and lascivious conduct with a child under the age of 16. I just want you to see, do you see this word right here? If you can't see it, I'll make it larger for you. Do you see what that word starting with F is? What is that word? FELONY. That is a felony. This is not a damn joke. That is a felony. Then we have the next one, lewd and lascivious exhibitionist on a child under 16 by a person over 18. This is a felony. Then we have contributing to the delinquency of a minor, which is probably the alcohol or the narcotics that are alleged that he had given her, which is a misdemeanor. This is in Florida. It changes from state to state, but this is Florida, right? This is Florida. So I feel like I got, oh, here it is. I'm trying to get my screen together. All right, there we go. All right. I mean, you're seeing what it is that I'm seeing, right? So, whereas we had the 2 original felonies, I spoke to a lawyer today, right? And I asked the lawyer, why would they decide to not pursue the first 2 felonies, which were the engaging in CHFASX 4/14. I don't know what that is. I Googled it. I couldn't come up with something concrete. I text the lawyer. I have not heard back from her. So The other one, sexual battery. So they decided not to, because remember, the assault was in her throat, around her mouth, and the fluids were found around her. So let's take a look, because if you think that these felonies are something to sneeze at, I'm going to show you what the let's take a look at the first one, right? We took a look at the first one. I need to make this smaller so that we can see this again, right? All right, so if you all can see up here at the top of the screen, right? All right. The crime of lewd and lascivious molestation by a person 18 or older on a child 12 or older but younger than 16 is a second-degree felony punishable by up to 15 years in prison and 15 years of sex offender probation and a $10,000 fine. 15 years. That is not a joke. 15 years is not a joke. Let's take a look at some of the other ones. Marie says she wants to call in. I'm not in the mood to have call-ins right now because I am triggered and I'm upset and stuff like that. We may do another video later, but I just wanted to show this real quick. But I'm gonna read the apples. I'm sorry. Let's get back to this right here. All right, L&L conduct / child, lewd and lascivious. So we had lewd and lascivious molestation. Now we're going to go to lewd and lascivious conduct, right? Here. So, 12 or older but younger than second degree. Okay, here we go. Lewd and lascivious, this is molestation. Up to 16, touch another person, lewd and lascivious. Let's see what it says here. It says, under Florida statute 800.45, the crime of lewd and lascivious molestation is committed when a person intentionally touches the breast, genital, or buttocks of a child younger than 16 in a lewd or lascivious manner, or encourages, forces, or entices a child younger than 16 to touch another person in a lewd or lascivious way. Strict liability of crime, penalties, adult minor, whether the child's lascivious. Okay, let's see. It's a long page. Like I said, I just saw that this was live. I decided to come live immediately. So I just wanted to give you all a sense because he's purporting this. And the thing is that I need, because I showed you all the video of the man who was a sociopath. I showed you all that video. You know that there are people out there who will lie to you. You know that there are people out there with diagnosed and undiagnosed mental health disorders that have them behaving in certain ways, like manipulation, lying, being a habitual liar, and attempting to contort the truth. And Lunar is saying, call it what it is, the R word. You know, we can't say certain words on YouTube anymore. So they don't want us to be able to speak forthrightly. Let's pull up another one of the charges. L&L exhibition, right? L&L exhibition, right? Let's see. Lewd or lascivious exhibition. The crime is second-degree felony punishable by up to 15 years in prison. So it looks like each one of these has about a 15-year charge. He has 4 of those plus a misdemeanor. 4 times 15 is 60. So it's like, yeah, you could sit up here and you could be on the internet talking your junk. Talk your junk now. And people send you commissary later. Or you get surprised with a sharpened end of a toothbrush. Listen. All I'm saying is this is the real world that we live in, and people don't like certain types of people inside. They don't like certain types of people inside. You hurt a child, people don't have love for you in there. So you sit up on the internet and you talk all of this. Well, you got on some frames and shades while you're sitting around trying to look fancy, but wear it now while you can.
Let's start it off with this conversation right here. Again, I won't be talking about the case specifically for all the right reasons. I have legal counsel. They're going to do what they got to do. What we are going to talk about is cyber defamation litigation. We are going to have a conversation about that. We are going to have a conversation about cyber defamation litigation. We are going to do that. And the reason why we're going to do this is because there's a lot of dishonest, wicked people out there. I've never seen nothing like this, where people literally prey on someone's demise. So I say it again. Both first-degree felony sexual assault charges have been eradicated. They're gone. Does this mean that there's no other fight? No, there's plenty fight. They came up with new counts. Of course, nothing compared to those first-degree felonies, which is crazy, because that give you life or 30 years in prison early. You dig what I'm saying? So yes, we will be turning up later on the strength. We will be turning up later on the strength. Is there still a fight? There's still a fight. But it's very interesting because a lot of people spoke out of turn, jumped out the window, accused me of things that not even the prosecution can. If the things that people say on YouTube was accurate, I mean, goddamn, you wouldn't even see me here today. You wouldn't see me here today.
We did see you today in a baggy suit.
So how the hell do these people on the internet know so much, but the legal system don't? The shit that people be saying.
You know what? I'm getting so angry right now. I can't do this. I'm getting so furious right now. I'm getting furious. I'm going to read the apples. Forgive the joyful music. Carol sends $1 and says, I love what you're doing. Thank you, Carol. I appreciate that. Thank you. Thank you. Kimika sends $2 and says, this just pissed me. You know, it pissed me off. It pissed me off too. I'm telling you, Kimika, this pissed me off. This pissed me off. Jella sends $1.20 and she says, love you, Tanya. You're a blessing. Thank you for all you do. And she sends a purple heart, right? Thank you. I appreciate that. Thank you. And let me get Jella some hearts up here. I'm sorry. This is just angering me. I'll come back and do the video. I'll come back and do the video just on his thing alone, right? On this. We'll analyze this video. Deborah sends $10 and says, truth equals hate to the black man in Sinji's voice. Yeah, shout out to Cynthia G. Keeping the foot on the neck of these nakers. Fawn, F-O-N-N, foot on the neck of nakers. Stacy sends $5 and says, phew, go off, sis. Listen, I didn't mean to go off, but sometimes you got to. You know, I have no love for the people who hurt children. No love at all. None. Marie sends $25 and says, I want to call in. I'll come back out a little bit later. I just need to calm myself right now. My spirit is so just frazzled from this mess right here. Mookie Lukey sends 333 and says, block Jim Jones. I'm about getting ready to get out of here. You know, you all too have the ability to block. Like if you see that I'm not paying attention to the screen, I'm looking. I don't see any comments from him. From Jim Jones. I looked earlier. I didn't see any. So just tell him to comment again because I can't block what I can't see. But I'm looking. I don't see him. Yeah. Somebody else said inside the comments, their blood is boiling. I don't see a comment from that person. You know, let's continue going forward. Monia sends $2 and says, drill, drill, drill. We like the dentist up in here, right? All right. And then we have Kiki, who says, thank you for reporting on this. Appreciate you. Thank you, my dear. We appreciate you. Thank you. Thank you all for coming through. I have to let me refresh and make sure that we have all of them. All right. All right. I'm going to jump out of here and I still don't see any comments from this person. All right. So listen, on that note, you all can continue to comment. We'll come through and analyze this other video later. I wasn't planning on doing a video, and I just need to just calm myself so that I can come out and make the best video possible. So listen, go out there and love one another. Most importantly, love yourself. And part of loving yourself is opening up your eyes and realizing that there are people who, one, who lie, two, who gaslight, three, who pretend to be ignorant and jump onto the sides of the assailant, and four, further victimize you by their allegiance to the people that they know in their heart have done wrong. It's as simple as that. They know. And so now this guy is going to try to pretend as if we can't speak on what it is that we have seen and read in the reports. Talking about we know more than the people in the court. No, we see the charges that are here publicly, and we have access. I just played the debut in court today. It's like, just wait and see, because we all know it takes some time for people to get prosecuted, and all of this that they're saying and doing. Then the next thing you know, you don't see nothing from them again. And then 60 years from now, when he comes limping out of jail, well, if that's how it goes down. Tanya TKO, and